Good morning, Phil. How are you, sir?
Morning, Christian. It's great to be here.
So we have exciting news in the world of privacy. We're going to talk about the California Privacy Rights Act, or as you like to call it, apparently CCPA 2.0. If you're in
The
the
evolution. Yeah.
Yep, here it is. Or GDPR Lite, because it does take a lot of terms and I guess concepts from GDPR, it seems like, to upgrade the framework a little bit. So I guess the bottom line is on the ballot was this new privacy law to upgrade CCPA that passed. I think that's no surprise. It seemed like, it had very popular support. So that passed on the ballot. And then I guess me and you took notes and really wanted to prioritize this, maybe a top 10 list, so that if you're an organization doing business in California, or if you are in California, you have a sense for the new stringent requirements that as an organization that you're going to have to follow. So first off, this takes effect January 1st, 2023. So there's kind of a 2-year period, which is very much like GDPR. They did something similar. Kind of working backwards though, there's a few requirements. So starting January 1st, 2022, there's this new requirement to submit a risk assessment to the state. Right, and that's kind of like a privacy impact assessment. Can you tell us a little bit about that, Phil?
Yeah, so anyone watching who's familiar with GDPR probably knows the DPIA requirement from GDPR. So California has more or less adopted something similar, with the special twist that it has to actually be submitted to the new enforcement body that California is going to create as a result of this act. So this assessment, it really gets into what in the EU they call the rights and freedoms of data subjects. So it's very focused on how data that's being collected and processed, shared, disclosed could potentially affect consumers. So it's a different type of assessment that has been getting a little more prevalent with the new privacy regulation, and now it's fully in the states with the adoption of this act, and in particular that requirement to actually submit it to the regulator.
Yeah, so if we're talking dates here, the legislation goes into full effect January 1st, 2023. You have to submit the risk assessment to the state by January 1st, 2022, which means this coming year, 2021, that's the year work has to get done.
It's a big prep year.
Yep, so it's a big prep year. You can't sit on it for 2 years. You already alluded to this. So the second big thing was that California is the first state to create an enforcement body. So there's going to be a regulatory body. I read that they're going to get $5 million in funding first year and then $10 million year after. I bet that's going to expand because they're probably going to have a pretty big caseload up front. But it has teeth. Bottom line, there's going to be someone trying to enforce that. It feels a little bit like HIPAA, where you have the health audits.
Good comparison.
So, so it'll be a lot like that, I bet. The next big thing that I wrote down that is a new requirement is you have to do an independent cybersecurity audit. So that's new. They use the word independent, so I don't know if that means third party or if they're going to let like a group of internal auditors that are independent do it, and that count. So that's unclear. But you do have to do an independent cybersecurity audit. So that's a big upgrade from just claiming compliance, I guess, or just claiming adequate security safeguards. I will say I did a little bit of research on that, and then I think the game we're going to have to play is, what is adequate cybersecurity? So California is unique in that they do have some case law, what they call the reasonableness test, and they've defined the reasonableness test as basically the minimum standard being the CIS top 20. So that's a pretty good framework. There's a lot of blocking and tackling there. So they have kind of a definition, which is unique. So if you're an organization doing ISO or SOC 2 or some of this other stuff, I guess it's unclear if that will pass the sniff test. I think it probably will. That's my sense if you're doing some other certification. But
it seems like it.
Yeah, but needless to say, organizations will have to do that. There's one thing that's less stringent that I think is applicable here too, is they've redefined what businesses this is applicable to. So it's not applicable to small businesses. It's really, I think, focused and targeted towards those larger organizations, Silicon Valley, of course, that are doing some heavy processing of data. Did you see anything specific about like the size of business in there?
So I think the big change is the number of records that would subject you to the requirement. So initially it was 50,000 households or devices, which really, if you think of how many devices are in your house, it's not hard to meet that threshold. So now it's 100,000 households. So that's probably the biggest area where small businesses might be affected.
Yep.
In a good way.
Yeah. In order of like stuff you have to do. So the next things people have to do is third-party agreements. That's going to be a big lift.
Yep.
So they've updated this concept of contractual agreements. So that's interesting because that's a B2B requirement. So if you're doing business and you're not in California, but you do business with businesses in California, well, the way they're probably going to get you is through a B2B agreement. So they're saying contracts have to be updated where you have to specifically limit the use of specific purposes. So like if you're a data processor and California is providing you data, you have to agree that you're only going to use it for defined purposes. And the other big one is mandatory right to audit clause. So it's unclear how often that's going to be exercised, but it's in there.
Yeah.
And if this is anything like GDPR, there was like that barrage of data protection addendums that happened after that, and it is still happening. I'll bet that we'll see that coming out of California as well.
Yeah, I think your DPAs will probably continue to just add appendices to make sure every specific phrase in a different regulation is covered.
Yep.
So at first it was, only based on the customer's instructions, and now I think CCPA or the CPRA is adding its own little twist on that. So
yeah, the attorneys out there will be very happy about the amount of contractual review they get to do.
Yeah.
So this is another big one, Phil, and I wanted to get your input on this one. So they've so CCPA really was about selling data, like if you're selling data back and forth, which was impactful and important. But they've really expanded that concept under this regulation to define this concept of data sharing. So even if you're sharing data, now you're under subject of this rule. So can you talk a little bit about what that means, like the sharing concept?
Yeah, there's, I think, a very specific ecosystem that this idea is going after, and that's cross-context behavior advertising. So where your data is being shared really outside of how you'd expect it to be shared. The idea really is kind of similar to profiling. So if there's one piece of data that a company knows about you, then that can tell them that you're more likely to buy their product, even if the initial piece of data they're getting doesn't really relate to their product. That's the idea of cross-context behavior advertising, and what this act is trying to cut down on.
Yeah, I mean, the word's targeted ads, right? So everyone doing ad selling out there is going to be hit. And I'm sure there's going to be other implications, but the obvious target is targeted ads. So that's going to be huge. That's going to impact everybody, even folks with websites. Like you think you gather a lot of marketing information and the whole cookie tracking thing. So that'll impact a lot of businesses. The next thing that I wrote down was they've kind of taken something, I think maybe from HIPAA, the sensitive information. So HIPAA has this concept of PII, or personal health, or PHI, personal health information, but they have sensitive personal information that they've defined and established some additional requirements around, I think, limit use of processing, special notice when you're going to gather it, kind of use. Phil, what's your analysis on that?
Yeah, this is another one that kind of ties into GDPR. GDPR Article 9 has its own definition of sensitive personal information. So CPRA has its own take on that. And it seems to me, looking at the act, that it's really focused on what you might call secondary purposes of processing. So the data might be collected to perform the service that a business normally does, but they throw it in their policy that they can use it for other purposes. And really it's focused on strictly limiting the use of that information to the initial purpose, the purpose that a consumer would reasonably expect.
Yeah, so there's a lot of requirements around these types of data. So like in the spirit of stuff you have to do if you're an organization. So you have to provide new notice. So like I'm envisioning notifications on websites and applications that you're collecting and how you're using it. Also retention, so how long you're going to store that data. They threw that in there. There's also the again another GDPR concept that you're only storing and keeping data for as long as you need it for the specific purposes of processing. So like I think they said need-based limitations. So you can't store data forever. You can't use it for stuff outside of the original purpose you collected it for. So a lot of the stuff that we do, Phil, around data inventory and cataloging and a privacy impact assessment. What is our purpose of processing? So a lot of that's going to be really formalized here for the U.S. that I think already existed in GDPR. So another GDPR concept they specifically threw out there was this concept of, and you've touched on it, automated decision making and profiling restrictions. So can you talk a little bit about that, Phil?
Yeah, this one, I think the CPRA kind of leaves up to regulations to decide exactly what the rule is going to be. So businesses are essentially on notice at this point, but the idea in GDPR is that consumers shouldn't be subject to a fully automated decision or a decision based on profiling without at least having the ability to request human intervention.
Yep.
So I'd expect something along those lines to limit the reach of automated decision making and profiling.
You know, where I wonder how this will impact, so there's kind of two places. One is like social media sites. So if there's like automated decision making on bans and things like that, I do wonder how it's going to impact that. Like, is that going to force a manual thing, or are you going to get notified? Also, the one that's going to impact us is maybe the mortgage industry, because there's like a lot of automated decision making when you go through a mortgage process, loan applications. The other one I called out specifically, was the job applicant process. So maybe for sorting jobs and stuff like that could be an impact, which brings me to the next one. So they do add some, I would say, some clarifications or some things that are less stringent. We already talked about the not applicable to small businesses. That was, I think, a fair clarification. The other one is this officially extends the exceptions related to employees, job applicants, and business-to-business contacts through January 2023. So I think CCPA also had that exemption, but it was due to expire this year, I think, come January 1st. Is that right, Phil?
It came through in the regulations, actually, but was just a one-year moratorium.
Yeah, so this will further extend that to 2023, but I guess the thought is after 2023, or starting in 2023, that exemption will be lifted. So I think that's in the spirit of that 2-year implementation timeline. They're trying to give organizations time to clean that up. But that'll be a big one because that's a lot of data. You think everyone's collecting job applicants. So you're saying everyone's applicable. Okay. So Phil, that's my list. That was kind of my top 12 list, I think it is. Are there other things that you wanted to highlight that are important here?
Those are definitely the ones that jumped out to me. I think in a lot of ways, this really just calls out the utility of a framework like ISO 27701. So one, it hits your cybersecurity audit requirement because you have the ISO 27001 piece that's a requirement, but also as this act incorporates more GDPR requirements, it's also covered in the 27701 standard. So it's certainly a business that has made compliance efforts around that framework is in a strong position today around the CPRA.
Yep, awesome. So cool. I think that's a good summary, Phil. If anyone out there wants to know more about privacy or wants to reach out and ask questions, you can reach Phil at philip.brudney@risk360.com. You can reach myself, Christian Hyatt, at christian.hyatt@risk360.com. We also have a bunch of white papers and blog posts. We have some data coming out on this act in particular and some action items that organizations can take immediately. And you can see all that on risk360.com and just look under the resources tab to find that. So Philip, thank you, sir, for your time. This is exciting developments. Talk soon, man.
Thanks, man. Have a good one.